Hello, everyone. Thank you so much for joining us and welcome to the Environmental Law Institute's very special last session of summer school, all about disaster and mitigation law. We have a fantastic lineup, a fantastic panel of experts waiting in the wings, so I'm going to go ahead and get started. My name is Sarah Viken, and I'm the manager of educational programs here at ELI. And if you aren't familiar with the Environmental Law Institute, we are a nationally recognized nonpartisan research, publishing, and education center working to strengthen environmental protection by improving law and governance worldwide. I want to take a moment to thank our lovely experts for joining us today. We have Rebecca, Alessandra, Steve, and Jerry, who've all taken time out of their very busy schedules to spend and share their expertise with us today. Now I'm going to go right ahead and turn it over to our wonderful moderator, Rebecca Kisslinger. Rebecca is a senior science and policy analyst at the Environmental Law Institute and the director of our wetlands program. She conducts policy research on local, state, and federal wetlands law policy and management, as well as ELI's work on climate resilience and hazard mitigation. And her work focuses on advancing nature-based solutions while promoting partnerships among natural resource management agencies and organizations, as well as hazard mitigation planners. You can find more information about all of our speakers on the event webpage, which again, I'll put in the chat in just a moment. Thank you so much, Rebecca. And with that, I'll turn it over to you to get us started.
Awesome. Thank you, Sarah. Thank you all for being here. We're really happy to have you today for this, as Sarah mentioned, our last in our 2025 summer school series, today focused on disaster and mitigation law. Today, we're going to start our discussion with an overview of the complex legal and regulatory emergency management landscape and the various actors that are involved. We'll talk about the Stafford Act, mitigation grant programs, and federal flood risk management standards. We'll then cover the Disaster Mitigation Act, state and local hazard mitigation planning, including some examples, and how legal professionals can engage with mitigation. And we'll finish today's discussion with a presentation on floodplain management, no adverse impact, and government liability issues. So a lot to pack in today, and we're really privileged to have an excellent panel, as Sarah mentioned, and we're really happy to have these folks with us today. To start, we have Alessandra Girolamo, who is the Director of Research at Loyola Center on Environment, Land, and Law. She's currently serving as the National Climate Justice Lead for the Climate Adaptation Science Centers. She's a community resilience specialist and applied researcher at the Lowland Center, as well as a co-founder of Hazard Resilience, the United States-based consultancy providing leadership and expertise in disaster recovery, risk reduction, and hazard policy. Dr. Girolamo is one of the founders of the Natural Hazard Mitigation Association and served as its executive director for 7 years. Alessandra is a subject matter expert in climate adaptation, hazard mitigation, and resilience, with a long history of working in public, private, and nonprofit sectors. She recently published Disaster Recovery Through the Lens of Justice and is the co-author of 2 textbooks, Natural Hazard Mitigation and The Private Sector's Role in Disasters. She obtained her PhD in 2013 on the privatization of hazard mitigation and received a JD from Loyola University New Orleans College of Law in May 2023 with specialization certificates in social justice and environmental law. Next, we have Steve Ferryman. He's the mitigation branch chief at the Ohio Emergency Management Agency. The mitigation branch administers FEMA's hazard mitigation assistance programs for the state of Ohio and is responsible for maintaining the state's hazard mitigation plan. Prior to joining Ohio EMA, Steve worked at the Ohio Department of Natural Resources Division of Water Floodplain Management Program for 9 years, where he assisted communities in maintaining National Flood Insurance Program compliance and providing technical assistance and information about floodplain management to Ohio communities. Mr. Ferryman helped develop and implement the Floodplain Management Program's first grant to Ohio communities, which provided funding and technical assistance to create local natural hazard mitigation plans. Steve graduated from The Ohio State University in 2000 with a Bachelor of Science in Sustainable Resource Management with an emphasis in water resources. He's a certified floodplain manager and member of the Association of State Floodplain Managers. And finally, we have Jerry Murphy. He's a state specialized program agent at the Center for Land Use Efficiency at the University of Florida. Jerry is a certified floodplain manager, certified urban and regional planner, and legal scholar. He leads the center's Flood Resilient Communities program. His work and research involve land use planning and control law, community-based planning, code and regulation drafting, floodplain and stormwater management, growth and infrastructure finance, post-disaster redevelopment planning, and community resilience and sustainability. Jerry works with local governments through applied research to craft planning approaches and strategies to address climate change, extreme weather, sea level rise, and other challenges facing local governments in the 21st century. So we have an excellent panel I'm really excited about today, and I'm going to turn it over to Alessandra to get us started. Thanks for being here.
Thank you so much. I'm just getting control of the slides here. And just one minor amendment to the bio. My apologies, this was entirely my fault, but I think I must have sent one bio back. And the role with USGS actually had the IPA finished at the start of this year. I just didn't want to misrepresent. So today I'm going to try my very, very best to cover a small piece of emergency management and related law and policy. 10 presentations wouldn't be enough. There's really a lot in this space. And so what I'm trying to do is really give some highlights, give the big picture, and there are a lot of resources that folks could go to if you're interested in learning more. You'll hear more from Steve and Jerry as well, but I'll be happy to post some things in the chat just for folks that want to dig in a little deeper. So to begin, it's important to note the role of federalism in emergency management in the United States. Emergency management begins at the local level. So first responders, you're familiar with police, fire, for example, they're the ones that respond when there's localized small events. And they are supported often by social service agencies, nonprofits, other partners. And we also often talk about people being first responders. When something happens, it's very often neighbors who immediately come to someone's assistance, and then we begin to see first responders. Now, of course, some disasters exceed the local capacity. When that happens, local jurisdictions, think of a town, a municipality, a county, turn to mutual aid agreements, which are more formalized agreements to share resources across counties, across jurisdictions. These take different forms, but one that folks are often aware of is what's called the Emergency Management Assistance Compact, or EMAP, which facilitates this kind of sharing by making sure that questions and potential issues around credentialing, for example, liability, who's going to pay for the use of the resource, or who's going to replace a resource that's used in a disaster or emergency, that those kinds of issues can be addressed. And don't mistake mutual aid agreements with this sort of broader umbrella of mutual aid. In the disaster space, a lot of folks talk about community-based organizations that provide mutual aid to each other. That's a less formal sharing of resources and capacity that happens between individuals. So I do want to distinguish between mutual aid in that sense as well. As the event escalates or the needs are larger, then you have state, territorial, and tribal governments playing a role. States have the ability to, for example, declare a disaster. And once their resources are exceeded, that's when the federal government is called upon. And generally speaking, the state will request a disaster declaration. It's also worth noting that the state can draw upon the National Guard for certain things, but really to talk beyond that about the military is beyond the scope of what we can do here today. Here is some language from the Stafford Act. Most folks are somewhat familiar with the Stafford Act, or at least its role in emergency management. The role of the federal government is to supplement the efforts and available resources of states, local governments, and disaster relief organizations in alleviating the damage, loss, hardship, or suffering. And I want to call attention to a few things here. The first is that the role is to supplement, right? As I mentioned earlier, disasters begin locally. Also notice the explicit reference to disaster relief organizations. So we're talking not just about what government itself can do, but also what its partners in spaces like the nonprofit sector, community-based organizations can do to assist as well. I didn't include this quote here, but it's also worth noting that in the language describing the intent of the Stafford Act, there's explicit reference to encouraging the development of plans, programs, and capabilities at the local level, encouraging insurance coverage, and encouraging hazard mitigation. So one thing that you will notice when we talk about the various acts and amendments in this space is that there is a focus on supporting local capacity, but also encouraging and sometimes nudging pretty hard to try to get local jurisdictions, states to make some investments on the front end that are going to reduce disaster risk. This slide shows the Stafford Act declaration process. As you can see, there can be emergency declarations and also major disaster declarations, as well as something referred to as fire management assistance grants. I won't go into this in great detail, but I will note that when you have the major disaster declaration, that's when we begin to talk about hazard mitigation grant program, not just individual assistance and public assistance. And I also want to note that there is an exception to this state request, and that is Section 501B, where certain emergencies that involve primarily federal responsibilities can be declared by the federal government. A recent example of this is COVID-19, but another example that some folks might be familiar with is the 1995 Oklahoma City bombing at the federal courthouse. This is a graphic that was created here in Louisiana, where I call home. This was created by the Governor's Office of Homeland Security and Emergency Preparedness in 2021 to help with their education and outreach efforts regarding the Stafford Act assistance process, to help essentially counties or parishes, in our case, and jurisdictions understand how that process goes. And as you can see, the governor declares a state of emergency. There's preliminary damage assessment. The governor requests a presidential declaration, and then that presidential declaration is granted. Of course, in some cases it's not, and that begins to put these other steps in motion. Now, it's not only the Stafford Act that we're talking about, so I wanted to take a minute here to sort of walk through a little bit of the history of legislation in the emergency management space. Between 1803 and 1947, there are at least 128 instances of documented federal disaster relief. And a lot of this was specific to a particular event. There might be legislation, there might be a desire to provide support to an impacted state or community. And every time there had to be a justification, and there really wasn't one process. The Federal Disaster Relief Act of 1950 was the first permanent authority for federal disaster relief. It was an effort to try to have a little bit more standardization. And it was followed by, among other acts, the Disaster Relief Act of 1966, which sought to actually improve the process for declarations when there were catastrophic events. And it created and authorized disaster loans at below market rates. And so you can look back to 1950 and 1966 as really laying a foundation in many ways for where we are today. A few other things that are worth noting: the National Flood Insurance Act of 1968, which was passed in order to create an insurance alternative. So one of the things that becomes readily apparent is that disaster losses are going to be a large cost, that the federal involvement could only grow and would end up bringing a rather hefty price tag. So a lot of this legislation focuses on how do we reduce impacts in the first place to reduce those costs in the long run. And one piece of that is to have availability of insurance. You then see in 1988, the Stafford Act itself passed. And the Stafford Act establishes a clearer process for declaring disasters. and it lays the groundwork for emergency management as we know it today. Note that FEMA had been created in 1979 by Executive Order 12-127. A few other notable changes: amendments such as the Disaster Mitigation Act of 2000, which sought to increase hazard mitigation and mandated certain kinds of hazard mitigation planning. I think you'll learn more about this from Steve. And then also the Sandy Recovery Improvement Act of 2013 that focused on the experience in recovery, but also on increasing access to hazard mitigation, and the Disaster Recovery Reform Act of 2018, which increased mitigation funding. And finally, note that the Homeland Security Act of 2002 placed FEMA under the Department of Homeland Security. And if you're familiar with your history of disasters, you might notice that several of these times sort of mirror or reflect large disasters that took place, where, for example, the Homeland Security Act of 2002 follows 9/11, and of course, post-Katrina emergency, Management Reform Act, Sandy Recovery Act. You can clearly see how this plays out. However, not all of the federal disaster assistance comes through FEMA, and not all of it comes through the Stafford Act. Some agencies can actually declare their own emergencies. For example, the Secretary of Health and Human Services can declare a public health emergency under the Public Health Service Act. The administrator of the Small Business Administration can declare an emergency. The U.S. Department of Agriculture can declare an emergency. So again, this is beyond what I'll get to today, but I just want you to be aware that although we think of FEMA and we think of the Stafford Act as being very central to emergency management, and in many ways they are, one of the challenges in emergency management is that we have so many agencies. We have over 30 entities with multiple programs and authorities, all of which run on different timeframes, have different requirements, and in many cases, we're dealing with a need to also avoid any duplication of benefits. And this is without even talking about the agencies such as the U.S. Geological Survey or the National Weather Service that have a role to play in forecasting or giving us the data, such as stream gauge data, that we need to both understand risk and respond. In addition to the legislation, we also have frameworks. Now, in this presentation, I'm not getting into the guidance and other details, but I did want to note that we have these frameworks and how they've sort of changed over time. In 1992, the Federal Response Plan was developed following the Stafford Act. It was revised in 2004 to the National Response Plan, which took an all-hazard approach once FEMA had been moved under the Department of Homeland Security. In 2011, as a result of the Post-Katrina Emergency Reform Act, Presidential Policy Directive 8 created the National Preparedness Goal and created a new set of frameworks that were not just about response. The National Preparedness Goal, which remains in place, is a secure and resilient nation with the capabilities required across the whole community to prevent, protect against, mitigate, respond to, and recover from the threats and hazards that pose the greatest risk. And there have been updates to the preparedness goal in 2015 and 2016. This slide shows you the National Response Framework as of October 28, 2019, where you can see the different roles that are played in incident management and response. And this slide shows how various planning efforts fall within PPD 8, again, Presidential Policy Directive 8, National Preparedness. And I know this is rather tiny, but all of these frameworks are publicly available. And you can see here, for example, the National Disaster Recovery Framework. And this was part of the effort to really bring all of this work under the umbrella of preparedness. Now, I want to mention the Disaster Relief Fund. The Disaster Relief Fund was created for activities authorized under the Stafford Act, and it is managed by FEMA. However, you also might recall that we often hear in the news questions around, will the disaster relief fund run out of money? Will more funds be allocated? Are disasters costing too much? And this fund is impacted by the Budget Control Act of 2011, which has an impact on the last 4 of those activities, but not the first. And so the types of activities authorized under the Stafford Act are activity pursuant to a major disaster declaration, pre-declaration surge activities, activity pursuant to an emergency declaration, fire management assistance grants for large wildfires, and disaster readiness and support activities. This graphic is from a CRS report, FEMA's Disaster Relief Fund. This is based off of data through January 10, 2024, and you can see the spread of how those funds are being used, including how much is being used on mitigation, individual assistance, and public assistance. And for those that are not familiar, individual assistance, this is the kind of assistance that individuals and households are eligible for following a declared disaster, whereas public assistance is assistance for the repair, reconstruction of public facilities following a disaster. So think, for example, funds to support rebuilding schools, roads, bridges, those kinds of activities. And those funds are subject to a match where the local jurisdiction, local government pays a portion. A few other things to note. We have a lot of risk that is actually the responsibility of the federal government. So you might have noticed in what I said about the legislation that there was this desire to have states, individuals, jurisdictions take on more responsibility for risk reduction and reduce the cost of disasters. But the federal government itself owns and constructs facilities. And so Executive Order 11988, Floodplain Management in 1977, directed federal agencies to comply with the National Flood Insurance Program, even when they wouldn't otherwise have to meet local codes and zoning. Now, compliance with the minimum requirements of the National Flood Insurance Program, and you'll hear a little bit more about this from Jerry, is not necessarily sufficient to prevent increasing flood risk. And so there are a lot of efforts, including no adverse impact, to have construction go to a higher standard. Think also of impacts of climate change, for example, or in floodplains, the flood depths can change as the nature of the floodplain changes, for example, a lot more construction. And so Executive Order 13690, which was initially signed in 2015, sought to have the federal government take into account not just current conditions and minimum standards, but actually go to a higher standard, a higher level. As you can see, it was revoked in 2017, reinstated in 2021, and revoked again in 2025. So this is an ongoing question as far as what will happen with 13690 in the future. And 2 other efforts that are worth noting. One is what was referred to as SWIFT, the Safeguarding Tomorrow Through Ongoing Risk Mitigation Act of 2021. It created a revolving loan fund, so looking for different ways to have risk mitigation. The federal government has done a lot of grants. The federal government has also sought to encourage communities and individuals to undertake mitigation on their own. This was a mechanism to try to also create a loan fund to support this. And also the Building Resilient Infrastructure and Communities program, which supports hazard mitigation. I mentioned the disaster component of the Stafford Act, but there also are hazard mitigation funds that do not require a disaster declaration, and those included in the past flood mitigation assistance and pre-disaster mitigation. Pre-disaster mitigation, however, depended on congressional appropriations as far as how much money would be available. When BRIC came in, the Building Resilient Infrastructure and Communities program, there was an effort to make sure that there would be a certain recurring amount of funding made available tied to the prior fiscal year's disaster declarations. I want to share with you this graphic from a report, Natural Hazard Mitigation Saves, which shows the return on investment of hazard mitigation. Again, you'll hear more about this from others, but it's worth noting that if we're going to be good stewards of federal dollars and also reduce misery and impacts at the community level, then it's important to think about what it is that can be done to reduce risk and impacts. And hazard mitigation, we know, pays off. And this shows you cost-benefit calculations regarding the benefits in dollars compared to the cost of certain kinds of activities by hazard. For example, adopting a code for riverine flood, wind, or earthquake. And I'll be happy to share a link to this report in the chat. I also mentioned BRIC. There's some uncertainty right now as far as what is going to happen with BRIC in the future, but it's worth noting that BRIC itself was insufficient. There was a lot more demand than available funding, and there was a bit of a challenge in terms of figuring out how to allocate the funds in what might be considered a fair fashion. And so much of that was still being worked out as we sort of get to where we are today. I also want to note this idea of nature-based solutions. We have seen a lot of federal agencies, state agencies, NGOs look to how we can reduce risk with what are called nature-based solutions. These are, to sort of describe them as simply and quickly as possible, solutions that rely on natural and beneficial functions of the ecosystem. So, for example, when you've seen efforts at dam removals, if you've seen green infrastructure in your community, these are the kinds of things that can be done that are not levees or not large gray infrastructure, but can reduce risk and in many cases actually be restorative to the environment. And FEMA had moved towards allowing funding for some of these kinds of solutions. Hazard mitigation is something that FEMA and others had hoped would be adopted at the local level. And in many cases it has been, but there is a direct correlation typically between what is supported by federal funding and other funding and what is actually considered a viable option in a community. And so expanding to include nature-based solutions is an important way to really expand what folks are looking at and thinking about in this space. Now, there's so much more and so much more than we can possibly get to. So I want to note that all of the work that is happening in this space, in the mitigation space, in the disaster space, is of course also subject to other standing requirements. Mentioned how many different agencies are involved in this space, for example, and they all have to attend to their own statutory requirements and their own programs. But you also have things such as Title VI of the Civil Rights Act of 1964, or the Americans with Disabilities Act of 1990 and its various amendments, National Environmental Policy Act of 1970, although of course there's some question right now about what that will look like, Archaeological and Historic Preservation Act of 1974, and so on and so on. And one of the reasons that it's difficult to talk about disaster law is because in many ways disaster law doesn't exist in the same way that climate law doesn't exist. Instead, we're interacting and intersecting with a lot of other areas of the law, including, of course, environmental law, every time there is a disaster or another event. Now, just to move towards wrapping up so that there's time for questions and for my fellow presenters, I wanted to just raise a few more issues, a few more thoughts. One is this question of federal data on climate, on weather, etc. Emergency management depends on data for forecasting, for response, and often in ways that might surprise you. For example, in the city of New Orleans, the Emergency Operations Center activates for events such as Mardi Gras or the Super Bowl, because even though it's not a natural hazard, there is a possibility for things to go wrong. And it's important to do things such as watch the weather. Or is there going to be a storm that might mean that the starting time of a parade during Mardi Gras has to be moved because the winds are expected to be too high for the parade to safely roll? That's just one example. We also have a lot of data that's collected through things like stream gauges. And so without this data, emergency management will not be in a good spot. We also need to ask how we account for climate change. Often in emergency management, we're looking back to the disasters we've known and we've seen, but we do know that certain things can change and are changing. For example, here in the Gulf where I live, we are seeing more and more hurricanes that exhibit rapid intensification, meaning that the amount of time that previously emergency managers could have counted on to be able to do things such as evacuate might be rapidly shrinking, and we might need entirely different plans for those events in which evacuation becomes impossible. There's also this question about what is the role for state and local government. Certainly, all disasters begin locally, and certainly local government, local emergency management is likely to know best in terms of who is in the community, what they might need, those kinds of questions. But when we have a large catastrophic event, take Hurricane Katrina, for example, since we're about to hit the 20th anniversary, it's difficult to imagine a state or a county being able to respond to an event of that magnitude. There's a lot of coordination that needs to happen across the entire nation around things like supply chains and bringing in search and rescue and buses and all of those components. And so in this larger public discussion right now, including proposals that are before the legislature, we do need to ask, what is this role for state and local government? And if more and more emergency management devolves to the state and local level, then what happens while we wait for perhaps state legislatures to approve budgetary changes, to have more resources? And what happens to persons who are in states that have less resources? And finally, what about human rights? One critique of the Stafford Act is that there has been a focus on assisting property owners on returning essentially to pre-disaster conditions. And we may need to be asking what happens for the unhoused, what happens for persons with uncertain immigration status. How do we make sure that human rights are protected, not just during disasters, but the rest of the time as well? Here are links to a few resources. I'll go ahead and probably share a few more in the chat, and I think these slides will be available, so hopefully folks can find these resources on their own. And my contact information, please feel free to reach out, and thank you.
Thank you so much, Alessandra. That was really great. So much to cover. Just like giving us a taste of this, what I teed up at the beginning is really complex. As we change over to Steve, we have lots of questions coming in, so that's great, and keep them coming. We'll save most of those for the end, but Alessandra, I wanted to ask one quick clarifying question as we change over to Steve. One participant asked if you could just explain the difference between an emergency and a disaster. So at the beginning, like, how do we go from emergency to disaster? Thank you again, and if you could answer that, then we'll change to Steve.
Yeah. There is language in the Stafford Act with regards to that distinction, and the easiest way to sort of simply draw that distinction is to say that it has to do with the extent of impact. So typically, if we're thinking a disaster declaration, we're thinking something that's much larger, more catastrophic. But there's more specific language that I'm happy to share as well. And there's also some question around when disaster declarations are or aren't granted, because there is discretion there. And there has been some research into whether or not there may be sort of political trends that align with that as well.
Great, thank you so much for that. Steve.
Okay, thanks, Rebecca. Can you hear me?
Yes.
Okay. So I just want to start by thanking the Environmental Law Institute for the opportunity to present to you today. I was asked to talk about mitigation planning and nature-based solutions. So I thought I would talk about an open space reuse project that I did back with ELI in 2017. There we go. So we're advancing here, I think. So mitigation is just one phase of emergency management, and we're constantly in some cycle of mitigation, preparedness, response, and recovery. Alessandra did a great job of talking about the Stafford Act, and pretty much there was a lot of legislation that was passed before that, but really the Stafford Act that was passed in 1988 is the basis of our current system of emergency management in the United States. As she mentioned several times as well, all disasters happen and start at the local level. And it's the local government that is the first responders in every event. When they get overwhelmed, they ask the state for help. And when the state gets overwhelmed, we ask FEMA for help. So in addition to setting up that basic framework of how disaster response and recovery unrolls, the Stafford Act also set some programs in place, specifically public assistance, which are dollars that go to communities to repair roads, bridges, and infrastructure after an event, as well as the individual assistance program, which is pretty much goes to help individuals, property owners that may be underinsured or don't have the resources to adequately recover from an event. That's what the individual assistance programs are set up to do. But it also created the Hazard Mitigation Grant Program, which is a program that funds mitigation activities that becomes available after a presidential disaster declaration in the U.S. And so real quick, the mission of the mitigation branch is up there, and I'm not going to read it to you, but listed below are some of the things that we do to strive to meet that mission. At Ohio EMA, we're responsible for developing and maintaining the state of Ohio hazard mitigation plan. So we work with our various state agencies and partners to gather input on what they feel the risks are for natural hazards around the state, and identify activities that can reduce risk to those natural hazards. We have to go through that planning process every 5 years, and we'll talk in more detail about that here shortly. We also have a planner on staff whose job it is to work with the 88 counties in the state. We have 88 counties, and we have 88 county EMA directors whose job it is to basically function as a mini FEMA unit. And part of their responsibility is hazard mitigation. And so they do hazard mitigation planning for their particular counties, and most of those plans are multi-jurisdictional. And the planner on staff helps to secure grants for them to update those mitigation plans. Those grants are getting a little bit harder to get with some of the recent changes in the FEMA grant program system, but he works with those communities to get grants to update the plans and then make sure that they have technical assistance if it's needed to develop those plans and write those plans so that they meet FEMA's criteria and can be approved ultimately by the state and FEMA. We also administer FEMA's 3 hazard mitigation assistance grant programs, BRIC that was mentioned a couple times. There's also the Flood Mitigation Assistance Program, which focuses specifically on mitigating losses to structures that are insured through the National Flood Insurance Program, and repetitive loss and severe repetitive loss structures. And then finally, that Hazard Mitigation Grant Program that I mentioned earlier. That's our only post-disaster program where funds become available after a presidential disaster declaration so that communities can undertake actions identified in their local hazard mitigation plan to reduce risk. So there were a number of changes that were mentioned by Alessandra to the Stafford Act, but one of the ones that was most important to mitigation planning was the Disaster Mitigation Act of 2000. And for those of you that are old enough to remember, we were all worried in the year 2000 about Y2K and all the changes that were going to come about as a result of that. But as it turns out, given all the preparedness that went into that and the efforts to turn zeros and ones and add the digits to dates, that was avoided. But there was some very important changes that came out of DMA 2K that affect mitigation planning. First, it required it established the requirement to do mitigation planning for states and local communities. Up until then, there was mitigation planning being done, some of it through the Flood Mitigation Assistance Program, and maybe some of it through other NFIP programs like CRS. But this established that states, if you want to get access for public assistance, which is again those dollars to fix roads, bridges, and infrastructures after a major disaster event, you will have a FEMA-approved state hazard mitigation plan in place. And it said the same thing for local governments. Local governments, if you want to have access to FEMA mitigation grant dollars after event, you will have a FEMA-approved local hazard mitigation plan that meets certain criteria. So that it couldn't be called an unfunded mandate. It also established a small pot of funds to help fund that mitigation planning for states and local communities. It basically said that the HMGP funds that are available to a state to distribute after a major disaster declaration, 7% of those funds can be used for state and local mitigation planning efforts. And it also increased the federal funds for mitigation projects based on the type of state plan. So it set up a tiered system for state plans. There's a standard plan, which is basically a plan that meets the minimum criteria established for FEMA for a state plan. And then there's an enhanced plan, which basically adds some additional criteria to the planning effort, but it also looks at how well a state is administering the FEMA grant dollars that are given to them for through these various mitigation programs. And are they doing basic things like turning in quarterly reports, for instance, and hitting all the milestones in your grant management process? And if you are doing both of those things, then every year FEMA would review that and make a determination whether the state is an enhanced plan state or not. So, as I mentioned, the Stafford Act is kind of the bones, but as often the case when Congress passes a law saying that thou shalt do something, it's up to the agencies to kind of put the meat on the bones for what that actually means. And that's what we have here in 44 CFR 201, the mitigation planning section that elaborates on Section 322 of the Stafford Act. It talks about mitigation planning. The first thing it does in Section 201.3 is kind of sets out the process for which, again, these plans will be developed at the local level. They'll be sent to the state. The state will make a determination as to whether or not they meet the criteria outlined here in 44 CFR 201. If the state believes that they do, they send the plan to FEMA. If FEMA concurs, then it's okay for the local community to go ahead and adopt that plan. So it kind of lays out that review process for the local hazard mitigation plans and everybody's role in that process. It also has that criteria that I mentioned for state and enhanced plans, as well as the specific criteria for local plans. And I'm going to jump to this slide here because, again, oftentimes what happens in these federal programs is Congress passes the law, the federal agency comes out with the rules, and then there's also guidance that goes along that helps further define what those rules are. When I was actually at the Department of Natural Resources at the time, this was back in 2002, and there wasn't guidance on the street yet from FEMA about how to actually do some of the mitigation planning activities. And so we developed our own planning guide in 2002. And any community of any size could pick up that planning document and create a plan that essentially complied with the federal criteria for mitigation planning. There's been several iterations of guidance since then, obviously. Most recently, in April of 2025, The current administration updated the local mitigation planning guidance, and the real update there was essentially stripping out some of the requirements to include climate change in local mitigation planning as a consideration, as well as some of the diversity, equity, and inclusion things that were included by the previous administration. So those guidance documents outline the process for how to do a mitigation plan, and it's really not any different than any other planning process that you might undertake. You first want to build support at the local level. You want to build your planning team, and you have to engage the public. Obviously, the more public involvement that you can get in the process as early as possible, you get that buy-in, the better the plan is going to be received and supported. If there's a difference in a mitigation plan to most other planning processes, it's that second step of assessing the risk. And in that step, you're basically looking at, what hazards has the community faced in the past? How bad has it gotten? How bad could it get? And kind of making a list of those hazards and a profile of those hazard events based on data. When it first started, some of the data sources for some of the hazards were pretty scant, but that library has since expanded quite a bit. Once you have a profile of those hazards, you can begin to look at, okay, well, what assets do we have as a community that are at risk to these various hazards? And how many residential structures, how many commercial structures, how many critical facilities, what type of roads, bridges, or infrastructure might be impacted if the worst event occurs. And that will allow you then to start to estimate losses. And again, there isn't any required format or formula to necessarily do any of this. It's left up to the planner and the data that's available to the planning team for each individual hazard and what is available locally. So these plans vary, I guess, in quality. And you get plans that are all over the spectrum. So once you've assessed your risk, the next step, you kind of go back to that nuts and bolts of planning, where you're establishing goals and objectives and actions, identifying mitigation actions to reduce risk. That's the strategy. You document all of that in the plan, and then of course, you want to implement the recommendations in that plan. All too often, we see communities get grant dollars to go through the process of developing these mitigation plans because somebody thinks that they should, or they think that they should, and they sit on the shelf for 4 years and they wait for the next cycle to apply for grant funds and do it again. If you're not implementing the plan, then you're missing the point here, because it's not planning that necessarily reduces risk. It's those actions that are identified in that plan that you need to apply for grant funds for, or some actions you can undertake, with your own funds, or some of the various other funding mechanisms. As Alessandra said very well, that it's not just FEMA that has emergency management and mitigation dollars. If you get creative in your grant writing, you can find mitigation funding from all different agencies. So the most important point probably to current and future attorneys that I'm speaking to here is that plan has to be adopted at the local level. And if it's not adopted, then the community is not eligible to apply for those FEMA hazard mitigation assistance grants at all. So certainly the help from the legal community, being solicitors and helping those communities to draft adoption documents and get those plans adopted is an important role. There we go. So I'm not going to talk too much about it here, other than to say we just went through the process in 2024 of updating the state hazard mitigation plan. We were fortunate enough to get an enhanced plan status again. in the state of Ohio. If you want to view that plan, there's a link where you can, it'll take you to our website and you can see PDF sections of the plan. It is a hefty document, weighing in at several pounds and 4 or 5 inches thick. But it does include a lot of great information on hazards in the state and activities and actions identified by state agencies to help reduce that risk. Just like the state plan is available on our website, all of the local hazard mitigation plans are available in a PDF format on our website as well. And there's a map, and I'm just showing you a clip here of that map. But if you click on any county, it will tell you the title of the plan. It'll take you to the PDF, and it'll tell you when that plan was approved and when it expires. So there's a wealth of information on that website. And I'll just walk you through here really quick we asked the local mitigation planners to input some data into tables on our website, specifically about that plan's hazard identification and risk assessment and vulnerability analysis. So for all of the hazards that the community evaluates, we want them to give a rating to the frequency, the response time, the onset time, the magnitude, if that event were to occur, what its impacts would be to businesses, people, and property. And if it's available and they've generated it, we would also want to know, again, for each one of those hazards, what type of residential structures would be impacted, the number of residential structures, the number of non-residential structures, critical facilities, and then a damage estimate if it is available for each hazard event. We also collect information on the various mitigation actions identified in those plans. We ask them to rank and prioritize those actions because that helps us when we're trying to help them develop mitigation grant applications for FEMA and or other programs. We want them to put, just basic information about each action, who's going to be the lead, how much it might cost, so on and so forth. So all of that information is available on our website. I wanted to highlight just one slide here where we have some overlap between mitigation planning and the legal practice. Certainly, if you have the good fortune of finding yourself a participant in a local hazard mitigation planning process at some time, one of the recommendations we make to communities when they're developing or looking at the various arrays of mitigation actions to include in a plan is to use the Stapley process, it's called, to evaluate those various actions to see, what it is that would best fit the community's needs moving forward. And that's an acronym for, is the action socially acceptable? Is it technically feasible? Does the community have the administrative people to make that action come to life? Is it politically acceptable? Is it legal? And that's where the attorneys would come in. All too often we would see actions and plans for, well, they need to do this or that at that core dam, or they need to increase the height, or that's just one example. But if you don't have the legal authority to do that, then it probably shouldn't be in the plan. And then the economic and environmental considerations as well. So there's that avenue to participate. I already mentioned the mitigation plan adoption and the role that attorneys would play in that. But as communities are implementing these mitigation plans and starting to undertake mitigation activities, there is certainly there's a lot of opportunities for legal involvement in the process. So one of the most popular mitigation actions that we have in the state of Ohio is acquisition and demolition of repetitively flooded structures. And we then deed restrict that property as open space forever so that nothing can be built there in the future. So in a grant project like that, you're going to have, closing on the property. You're going to have deed review and recording. Then after the project is closed out, FEMA requires in 44 CFR Part 80 that the state report every 3 years to FEMA on the status of those open space properties. Are they still open space? And we are pretty religious about doing that here in the state of Ohio, because if you're not, then you shouldn't be doing open space acquisition projects. And we've actually encountered and do every 3 years issues that we have to work with attorneys here at the state and or local level to help us resolve. Could be as something as minor as, there's somebody was illegally dumping on the open space lot to we've had structures built on lots that we've had to have people removed. So it can get fun. I haven't seen a local mitigation plan yet that doesn't talk about, as a community, we would need to update this ordinance or adopt that building code or implement this zoning code or update that subdivision regulation. So there's a lot of opportunity there for input from the legal community and how to best do those things to help the community avoid damages in the future. And then last but not least, when you're doing a federal mitigation grant, you have to follow federal procurement rules, and those rules may not be the same rules that a local community would follow for any other activity that they're undertaking. And so, there's an opportunity there, as well as, signing contracts for various private sector entities to do work related to mitigation projects. And there's requirements, again, at the federal level for certain things that needed to be added into contracts in order to make those legal from a grant management perspective. So again, back to our mitigation webpage here. Just like we track all of the mitigation plans, we also track all of the projects. And if this is our landing page for our website, and you'll see we have one of here in the bottom right, an estimate of the number of properties that we've mitigated using FEMA Hazard Mitigation Assistance grant dollars, as well as an estimate of the damages that we've prevented based on the benefit cost analysis for each one of those grants that FEMA funds. There's a map, again, where you can drill down into all of these projects and get a lot of detail about the costs and how they were implemented and who implemented them, and photographs, so on and so forth. So that information is all out there on our website. And if you're curious about it, I recommend you take a look. I'm going to shift gears here from mitigation planning a little bit now and talk about some of the nature-based solution and open space reuse that I was asked to bring into the presentation. And I want to talk about a project that I did with ELI and Rebecca back in 2017 in a small village in northwestern Ohio called Ottawa in Putnam County, Ohio. And this is a village of about 4,500 people, really nice, small, tight-knit community with a big flood problem, unfortunately. These photographs are, I believe, from 2011 and 2017, but they got severely impacted by flooding in 2006, 7, and 8. And as a result of those flood events, that led them to apply for and receive FEMA mitigation grant dollars to do a lot of acquisition and demolition projects in the community. And they I think ended up applying for somewhere around 10 or 11 different grants and ended up acquiring somewhere in the neighborhood of around 80 different parcels within that community. And I think there's only 1,800 structures in the entire community. So we bought out about 10% of the village. And, we couldn't have done it without the strong leadership of the local floodplain administrator and the mayor at the time and several council people. But, this floodplain map shows you just how big of an issue the flooding problem is there in the community. And some of these open space parcels here were highlighted on the map in yellow and orange to show you the location and the size generally of what it is that we're looking at here. So I was contacted by Rebecca and said, hey, I'm interested in working with communities that are struggling with how to manage these open space properties. And the first thing that came to mind was the village of Ottawa. And so we set up a meeting with the mayor and all of the government officials in town. They invited all of the heavy hitters in the village, all the local businesses, the school districts. Was very well attended meeting back in, I want to say, August of 2017. And the point of the meeting was for us to go through and try to talk to them about, hey, there are some creative and innovative things that you can do with these open space parcels in your property. They don't just have to be a burden for you to mow and to take care of. And when we started to kind of shift that thought at the local level, we started getting a lot of great ideas about things that could be done on these properties. And those ideas were captured in a report written by ELI that was published there in November of 2017. And it really, the locals really bought into this. And what you see here was a sign that was erected in downtown Ottawa. And they figured that it would take somewhere on the order of $550,000 to do a lot of the actions that they wanted to do that were identified in this plan. And they started to collect donations from local folks. And as you can see, the squirrel was pretty rapidly moving up the tree as donations were collected to make some of these open space ideas a reality. And we'll go through some of these real quick, and then I'll wrap up my talk here. But one of the properties they developed a park on, Arrowhead Park, and this was the former site of a manufactured home park, which had 19 or 20 manufactured homes in it, and those were totally bought out. And this was turned into a nice park, along with a canoe and kayak access point. The grass hadn't grown up when they took this picture, but now it's got a nice bit of grass around it, and it's a really good amenity for the community. Here's another example of a dog park that was built on one of the buyout parcels closer to town. This is what they refer to as the West End Soccer Field Complex. It's a little bit hard to see in this photograph, but you can see the field there in the forefront, and there's another soccer field there in the background there by the water tower as well. And so the kids are playing soccer here, every Saturday and Sunday on the weekends. One of the coolest things that they did was there was a large parcel in downtown Ottawa that was known as, that it was the former site of Paul's hardware store. And the building was just wasn't going to stand anymore after being repetitively flooded. It was purchased, knocked down, and they wanted to build, because this was located pretty much right in the center of town, they wanted to build, a focal gathering point for the community. And so they built this stage, and they have concert events. There's, I would say regional or maybe even national country acts that come to the town once a year and perform at this stage. They have plays. They have all kinds of events. The picture on the right there is from the ribbon cutting for the actual event. So it's just a really nice feature. And if you go on their website, it's very prominently highlighted on the community's website about how proud they are of the work here that was done as part of this. And I didn't, due to time and constraints, I wasn't able to get pictures and slides, but these were just a list of some of the other activities that were identified and actually implemented by the community as a result of this project. And each time a community wants to undertake an activity on open space, they have to pull together a bunch of plans and descriptions and forward that to the state, and the state sends it off to FEMA, and the regional administrator here is in Chicago. They have to review and approve all of that, and then it comes back down that way. So it was a lot of work for them to do this, and a lot of planning and a lot of money. And I know they're very thankful for the work that ELI did, and so am I. And so with that, I will wrap it up and turn it to Jerry.
Thank you so much, Steve. That was really great. I really appreciate you highlighting that example as was a really great opportunity for us, and I'm really happy to hear all these things. I mean, I've seen some of it, but really happy to hear what the community is doing. Just as we change to Jerry, I have one question. I really appreciate your slide and all the things that our audience, law students and the legal profession can do to get involved. Can you just say a few words about what the entry point is, how they find the person, or office where they can start those conversations? And I also encourage everyone to go find their local hazard mitigation plan. Like you said, Steve, yours are all posted on the state's website, but you might have to Google or in other states to find it. But can you just talk a few words about how they get involved?
Yeah, so a lot of the smaller communities in Ohio don't have the funds to have an attorney on staff, and so they may have a contract attorney, and so that's certainly one way that these local solicitors can get involved. But the larger communities are going to have staff, legal staff that hopefully are involved in the process, as early as possible, because it's not going to do anything but help to avoid pitfalls moving forward. So I don't know if that answers your question or.
Yep.
Okay.
Good start. Awesome. Thank you so much, Steve. And we'll turn it over to Jerry.
Hey, everybody, can you hear me?
Yes.
All right, great. So I appreciate Rebecca's introduction and wanted to add a few things in conjunction with today's presentation. I'm also with the Association of State Floodplain Managers Leadership. I'm the Higher Education Committee co-chair and also the Academia Regent for the Certification Board of Regents that administers and maintains the Certified Floodplain Manager exam, CFM exam, and also on the Education and Partnership Committee for CEPOL. So on the left-hand side of this slide is an overview of what we'll cover today. And on the right is our team of collaborators for the No Adverse Impacts Legal Guide, lawyers Thomas Rupert with William and Mary and John Ryan Henry with the Coastal States Organization, Terry Turner and Janet Thigpen, Certified Floodplain Managers and co-chairs of the ASFPM No Adverse Impact Committee, and yours truly with the Flood Resilient Communities Program at the University of Florida. So we wouldn't be good lawyers without beginning with a good caveat, so here it is. And also keep in mind that we're discussing floodplain management and law generally across the whole United States. While there are broad brush similarities in many areas across the states, ultimately tort law, property law, and water law are inherently creatures of state law, so variations do exist, and thus this caveat. So what do we mean by no adverse impact floodplain stewardship? And why do we use this concept as a framework for a collection of legal resources related to floodplain management? This is a working description of no adverse impact. It's an approach, a concept, a philosophy that strives to ensure that we don't harm one another, either persons or property, with negative impacts caused by activities or development by public or private entities. The NAI approach seeks to protect property rights, public safety, water quality, and the need for public services, just to mention a few of those impact areas. We're using the term floodplain stewardship to forward shift our thinking about human occupation of the floodplain. It is important to manage human activities in the floodplain, elevate necessary buildings and other structures, avoid fill, prevent unnecessary encroachments, etc. But we also want to think holistically about our planet, its ecosystems, and natural and beneficial functions of floodplains in that light. So this is how we describe floodplain stewardship. We need the NAI approach because flood damages and associated costs are escalating. The minimum federal standards established under the National Flood Insurance Program, or NFIP, aren't adequate to prevent even more damages to property and many other flood hazard impacts on communities and individuals. Even if we perfectly implement the NFIP minimum regulatory standards, the damages from flooding will continue to mount. Current approaches deal primarily with how to build in the floodplain rather than how to minimize future flooding impacts and risks. This approach might be reasonable if the community's only concern is to balance private property rights against the vulnerability of new construction to floodwater damages. But what about the community's obligation to protect citizens' health, safety, and welfare? What about the rights of neighboring property owners and the community at large, and the need to mitigate against the real peril of flood? There are limits to relying only on the minimum floodplain development performance standards required for participation in the NFIP. First, there are no restrictions on where to build, and there's no protection of floodplains, wetlands, and other sensitive areas. There are no limits on siting critical facilities, and fill is allowed to be placed in the floodplain where it, in turn, increases flood hazards by displacing and diverting flood waters. Let's not forget, the NFIP is a flood insurance program, not a land stewardship program. It is, unfortunately, however, the only land management program some communities have when it comes to regulating floodplain development. And some communities don't even have NFIP's voluntary program required for the insurance eligibility. The NAI approach may include policies or programs that either mitigate or prevent negative impacts caused by human activities in the floodplain. But NAI does not mean that the community has to deny a permit for a proposed project in the regulatory floodplain. It does require employing creative strategies to mitigate against any adverse impacts on that particular development project. Communities might choose to purchase properties at risk of flooding for public use. Some of the examples that Steve showed. Maybe it's an ideal location for a public park that may also store stormwater in a flood situation. If recently flooded areas were undeveloped, the community could revise their floodplain development standards to protect future development from higher flood levels and risks. NAI is locally driven. The approach being potential development impacts are identified, evaluated, not only at the project site level, but throughout the regional basins or entire watersheds. And then those impacts are accounted for in mitigation measures to reduce or eliminate the flood potential to harm or otherwise adversely impact others. NAI transforms the concept of floodplain management to a more comprehensive approach to flood risk reduction and floodplain stewardship. NAI is not just an approach for land use regulations and development permits. It's an approach that can be integrated into all of the community's activities that affect the floodplain or stormwater drainage. There are 7 existing building blocks in the NAI toolkit, and they're listed in this slide. An ASFPM has developed guidance materials for each of these activities to help communities incorporate the NAI principles into existing and ongoing community programs. And these are all available at the ASFPM website under the No Adverse Impacts tab. So to wrap up the NAI overview, NAI is a win-win approach to higher standards in floodplain regulation. It's a good neighbor policy that provides the foundation and the tools to help communities fulfill their responsibility to protect the health, safety, and welfare of their community's citizenry, infrastructure, and land from flood hazards. And as I mentioned, more information about NAI can be found on the ASFPM website. That's www.floods.org, and just click on the NAI logo from there. So now I'm introducing our newest resource to help communities develop and implement effective and legally defensible NAI floodplain stewardship programs and regulations, and that's the NAI Legal Guide. It's an online resource, and here's the web address. There's a QR code and a few screenshots of the publication. And the site allows users to download a PDF file for the entire guide, and that's that big blue button at the top of the right-hand screenshot, or any of the 5 major sections of the guide. So let's discuss legal aspects of floodplain management and regulation, beginning with the common law. The majority of states in the United States have aspects of common law or judge-made law carried forward from England and the United Kingdom during the colonial era. Common law refers to the part of English law derived from custom and judicial precedent rather than legislative statutes and administrative regulations. The common law is the body of English law as adopted and modified separately by the different states of the United States and by the federal government. The common law has been and may be modified by statutory law. Tort law is common law that has been modified by statutory law. And the most common torts that we can look at in floodplain management are negligence, nuisance, trespass, and to a lesser extent, the law of surface water. So what is a tort? It's a civil, as opposed to criminal, injury or wrong for which the law provides a remedy. There are intentional torts, such as assault, battery, trespass, and intentional infliction of emotional distress. But the most common tort that comes up in the floodplain management realm is negligence, which does not require intent. Negligence requires that there be some duty of care, a breach then of that duty, a causation, person who actually inflicted the tort, and there must be damages, and then they can be compensated. But for local governments and state governments and federal government for that matter, there is also sovereign or governmental immunity. Anybody remember Monopoly? That's kind of the get out of jail free card. So let me go a little bit more deeply into governmental and sovereign immunity. This is basically what comes into place when citizens sue their own state or some subdivision of the state. And when determining whether a citizen may sue a state actor, that's someone who's acting on behalf of the state, say a state employee, courts will typically use one of 4 tests: the governmental versus proprietary function test, which asks, was the actor functioning in a governmental fashion or a proprietary fashion? If the actor was performing a proprietary function, like acting for financial gain for itself or its citizens, or doing something that is not historically a governmental function, maybe doing something that can be performed by a private corporation or contractor, then the actor is subject to liability. But if the actor was performing a governmental function, i.e. acting for the general public, doing something ordained by the legislature, performing a historic governmental function, then the actor is not subject to liability. In the ministerial or operational versus discretionary functions acts test, The question is, was the actor performing a ministerial, operational task, or a discretionary task? If the actor is performing a ministerial or operational action, then there is no immunity. But if the actor is performing a discretionary function, then there is immunity. Third is the planning versus implementational test. Was the actor planning an action or implementing an action? If the actor's planning or policy results in harm, then there is immunity. If the harm happens due to the government's implementation of the plan, then there is no immunity. And finally, the non-justiciable versus justiciable test. If the actor's action was justiciable, that is reviewable by a court under regular tort principles, then there's no immunity. But if the issue is not justiciable under regular tort principles, then there is immunity. Besides torts, especially negligence, the other legal cause of action often raised in floodplain development regulations is takings. If the floodplain regulatory scheme makes clear that the basis of the regulation is to prevent serious harm and injury, then it's almost a guarantee that a carefully drafted regulation will not be held a taking of private property rights. The legislating government must couch the regulation within their police powers, that is, to protect community health, safety, and welfare. And don't forget about property rights. The Supreme Court's taking jurisprudence is outlined by these cases and the following general takeaways. If it is not necessary to provide others access to private property, try to avoid interfering with an owner's right to exclude others from their property. This includes putting things, such as excess water, onto their properties, which may also trigger the tort of trespass. Again, while it is best to avoid, when possible, rendering any parcel of land valueless, that does not necessarily mean that if a house cannot be built on a parcel, the parcel has no value. Courts have repeatedly noted that open space, camping, bird watching, hiking, and buffer space are some of the many uses other than building development that may contribute value to land. As for permit conditions or exactions, we broaden the advice to say that you should avoid negotiations with property owners. While negotiations may seem like a great way to be reasonable and flexible in your role to balance flood protection and the use of property, in the Koontz case, offers of permit conditions to mitigate the negative environmental impacts that would have caused the state agency to otherwise deny Koontz's permit application got that state agency in trouble. The court held the offer of mitigation options was an exaction that triggers more searching judicial review. And Koontz is having an impact. State court cases are starting to find a takings for mitigation requirements, such as those contained in tree ordinances or ordinances aimed at mitigating wetland losses or traffic impacts. This is too complex to dive into for this presentation, but the NEI legal guide should continue to address this developing area. For now, if you have any mitigation requirements of any sort for permits, be very careful to ensure that, one, they are directly related to the reason for otherwise denying a permit, and two, any burden imposed on the property owner is roughly proportional to the impact of the proposed activity, and three, that you have made individualized findings about the impacts of the proposed development activity. This last point underscores the need to be proactive in reviewing planning and zoning to ensure that what is legally permissible is what the local government is willing to accept. Once someone acquires property for the express purpose of a project or begins discussions with the local government about permitting for a legally permitted use, the community is on thin ice, making changes to stop it. Do not attempt to alter application of program rules to accomplish something outside of addressing flood risk, such as going after specific property owners or stopping a project that meets relevant legal criteria but is unpopular. These actions will get you in trouble. So I hope I've made the point that clearly basing regulations on preventing demonstrable harms from flooding provides a strong basis for regulation, making it very unlikely that courts will either invalidate such regulations or, if the regulations are carefully constructed to focus on flood risk, will be found to be a taking of private property rights. While this is generally true, there are, of course, never any guarantees. Little can prevent you from being sued. The point is to prevail. The asterisk case of Lucas versus South Carolina Coastal Council noted here is an example of another outlier case. But as we have read court opinions from around the country, one striking thing that is coming into view is that many court opinions not coming from the U.S. Supreme Court often seem to be working to get to a reasonable resolution of the case in front of them, rather than trying to make ideological points about property law. For example, while the Lucas case in 1992 was originally thought to be a watershed moment for the expansion of property rights at the expense of government to regulate to protect people and the environment, the difficulty of rationally, logically integrating the Lucas case's statements with other takings cases has limited its applicability. One study found that only 1.6% of over 1,600 Lucas claims reviewed was successful. So to wrap up takings, there's lots of conflicting case law. The case law and its jurisprudence is extremely complex. It provides opportunities for very carefully frame actions. Courts have used complex ideas in framing where they want to get with particular cases. And good faith, careful, thoughtful regulation done through transparent, appropriate processes are quite safe, even when the impacts to the property are severe. And try not to forget, bad facts make bad cases. This last point really applies both to tort and to takings law. It may not always be important in tort law as in takings law, but ensure that you are doing everything in your power to ensure treatment that a court can find its way to view as fair. If the court is convinced by the evidence that how and what you are regulating is very important for the public's health, safety, and welfare, which should be an easy sell as we see increasing flooding losses, then you'll probably prevail. But if the impacts of the regulation are severe and there is any hint of bad faith, shady, or underhanded actions in your process or substance, beware. Clarity, evidence, integrity, justification, and transparency in both substance and proper procedures will go a long way to prevent your higher regulatory standards from giving a court bad facts. Though, again, there are never any guarantees. And so here are some of the next steps that we're looking at with regard to the NAI legal guide. There's more legal content already on its way. We think we published in 2022, and the whole section on executive orders has probably been repealed. We're also working on, because it's more of a legal guide, we're working on a sort of condensed version that is addressed at floodplain managers, more of a lay version. And we're also looking for input from folks who are using the guide. You know, how can we make it better? Have we done anything wrong? Is there something that we've missed? You know, the more input that we can have, we really appreciate it. And you can please send that input to Jeff Stone, jeff@floods.org. And with that, I will wrap up my presentation.
Great. Thank you so much, Jerry. That's really important. Sarah, can we put that back on just so people have the QR code for a minute more? That's a really important resource, and I hope everyone takes a look at it. And you know, if you do have some input for the folks listed, that please send that along, and we'll also link to it on our event page. Just wanted to remind you in the chat, Sarah has indicated, and I wanted to reiterate that the slides and the recording will be available on our website on that event page, so you can turn to that to find those. And that in the Q&A, there are some answered questions from some of our panelists, and you should all be able to see those to follow along. So some of your questions have been answered in the Q&A box already, and we may turn back to those. But I just wanted to start by thanking our panelists. As with all of our summer school topics, we could do an entire summer on these areas of interest. And so we've really started to just scratch the surface here, and I really appreciate that. These presentations were really great. We covered a lot. But I know we have some questions coming in the Q&A box, and I did want to sort of start out high level for the panel, and you all sort of mentioned or did mention explicitly that, you know, disasters and disaster response starts locally, and the importance of local and state response. But I wanted to talk if you could talk just a little bit about the role of FEMA, especially in the coordination of all these responses. You know, we've talked some about that. Alessandro, you mentioned that as well, but just to sort of more broadly answer some of the questions that are in the chat, what that role is of this federal agency in disaster response, recovery, and mitigation.
I'll start. I'll take a crack at it. I think that the public's perception of what FEMA should be doing versus what FEMA is supposed to be doing is very different. I think that the public thinks that, you know, FEMA a lot of times is the first responder, and when that bad thing happens, that FEMA is going to automatically show up, sometimes with sacks of money, and say, you know, we're here to help. But that's just not the way the process works at all. And you know, what FEMA's role is to work with the state. You know, when the state asks for resources, if FEMA is able to work with its federal partners to bring those resources to the table, that's what their role really is. And that coordination happens through local emergency operations centers, up through the state EOC, and then to FEMA. You know, FEMA is going to show up 9 times out of 10 in the state EOC when that event happens. They may have satellite offices or so on and so forth, but their role is to really coordinate the federal response to an event. And please feel free to add to that if
I would add something if it's okay. I think there has been a lot of conversation lately around what FEMA's role is and should be, and several prior FEMA directors have weighed in through blog posts and other avenues. And, you know, like Steve pointed out, I think the public expectations of FEMA don't necessarily align with what FEMA is able to do. And sometimes I think elected officials have not helped with that. There's sort of this tendency to come to a disaster and promise to make everybody whole in ways that the agency can't do. There are, however, some things that the agency does that a lot of people don't necessarily recognize that do fall under the sort of capacity building so that local government can lead better. For example, there's a lot of training for local folks that is funded through FEMA, and it does make sense to have national standards. Somebody asked a question about the National Incident Management System, right? Making sure that first responders can talk to each other, use the same systems, have an incident command system set up. FEMA has also played a role in funding local emergency management, particularly in kind of rural and remote areas. There are a lot of parts of this country where the local emergency manager is maybe part-time, would not really have funding for even the basics without these FEMA grants. It is possible that we could look to having the states sort of step up and fund more of that. There's questions around how they could, if they could, how quickly, but that is part of what FEMA has been doing. And there is also, you know, this larger coordinating role, again, when you have large regional catastrophic events that sometimes can even almost entirely wipe out local capacity, at least for a little bit, right? Think about what might happen in a Cascadia earthquake, for example, right? You're going to need more resources than the locals can immediately bring to bear.
And I'll just add that in the floodplain management realm, FEMA's role is primarily with compliance. Once a community is in the National Flood Insurance Program, guidance and publications, and as Alessandra mentioned, training.
Yeah, thank you for that. So now going a little bit, or a lot more specific, maybe there was a question on the federal disaster funding sources that trigger 42 USC 5154A, the mandatory flood insurance purchase requirement, and asking if there's a crosswalk available for floodplain managers to prepare if the special flood hazard area gets remapped, and those structures now need to be managed at the local level. Any thoughts? Ian, I hope I did your question justice. So maybe generally, floodplain mapping and, what to do when those areas get remapped. Maybe Jerry, Steve. Yeah.
Well, I mean, I can talk about my experience and knowledge, I guess, with the mandatory purchase thing first, is that, when you go to purchase a property and you apply for a federally backed loan, that's what triggers the requirement for mandatory purchase of flood insurance if that structure is located in a FEMA mapped flood hazard area. And so mandatory purchase, in my opinion, it is a good thing. And unfortunately, we have folks that have found workarounds for that various ways. A lot of times in small communities, especially in Appalachian areas of the state of Ohio, you'll have properties that are passed down generation to generation. And so, if there's no mortgage on that property, then there's no requirement to carry that flood insurance. And people oftentimes don't see the benefit of having that flood insurance until it's too late. We have, in most flood events that occur across the country, they do not result in FEMA help. They're just not, they don't escalate to the federal disaster declaration. And when they don't, and the state doesn't have programs that can help, and a lot of states don't, that flood insurance is going to be the only way that you're going to be even close to getting back to whole after an event. And so, I know that flood insurance premiums are increasing, and it's a tough sell, especially to folks, lower income folks, to buy it. But when you look at what you're getting for what it costs, there's just a lot of folks don't realize that even if FEMA does come to town, if the event is big enough to trigger FEMA help, the individual assistance program, and I'm going to be off on my dollar amount here, but the max amount that you're going to get from a FEMA individual assistance grant is somewhere on the order of $35,000 to $40,000. So just imagine you've lost everything you own. You've lost your structure, you've lost your contents, you don't have insurance, there's nothing, and FEMA comes and writes a check for $35,000. You're going to go through the roof because that's not enough to replace all that stuff. And people don't realize that often until it's too late.
If I could add,
Please.
also the obtain, maintain requirements after having received federal assistance, including federal loans like the SBA. I think it's worth noting that people aren't always aware that those exist. I think people are dealing with a lot of stress after a disaster. They're signing papers, they're doing the best they can. Maybe they don't really realize that it has to be carried at that property in perpetuity, regardless of who owns it, to be eligible for federal assistance. And what happens to folks sometimes is maybe they've inherited a property, maybe they purchased it. Maybe they know it had damage before, but they don't know it had an obtain, maintain requirement on it. They go to file for assistance, and then individual assistance returns back a rejection because they weren't carrying flood insurance. And so that is an issue that folks need to be aware of. And I would love to see more of a crosswalk. I have not seen one.
Yeah, and I'll just add that financial institutions are requiring flood insurance even if the property is not federally backed mortgage, and even if it's not in the special flood hazard area. It's increasingly becoming an additional requirement.
Great, thank you. And just to stay maybe a little bit on the insurance question there, and I know, Alessandra, you did answer some of this in the chat and the Q&A, but there were some questions around private insurance and the role of private insurance. Maybe Alessandra, you could just talk a little bit about that, and if others have comments.
Yeah, I could talk a little bit, but I'm not an expert in insurance, so I want to be careful in what I say. And I did share some resources. There's folks at EDF like Carolyn Kutsky, who used to be with the Wharton School, that are doing a lot of work in this space. And Louisiana Sea Grant has done a lot of work on the mandatory wind pools. I think there's two places to look at that, right? There's sort of wind insurance, where we're seeing that as insurance policies get unaffordable, some states are setting up risk pools to try to reduce costs and kind of guarantee availability, but those are funded in different ways, and sometimes they're dependent on how much money is in a state's emergency fund. And so we do see insurers go bankrupt and those pools struggle. And folks also are purchasing, I may be using the wrong term, but unregulated flood insurance policies, right? Or I'm sorry, wind policies, right? That don't have all of the same protections that other insurers have. And in the flood space, the NFIP was created in part because the private sector wouldn't insure for flooding. But there are some private insurers for a very hefty fee in some cases that could be available, like Lloyd's of London, for example, and insures in some places.
Mm-hmm. Other thoughts? Okay, great. There's a question more specifically about sort of the definition of disaster, and if that includes more sort of slow onset or slow moving events, or like sea level rise. And so maybe talking a little bit about that, like what qualifies as a disaster, and does that include these slower moving events?
I can give it a shot. It's a little bit outside of my area. So in the state of Ohio, it's the recovery branch that kind of pulls together the letter that if we are going to request a presidential disaster declaration, that, you know, the recovery branch would pull that together. And I know that I believe it's the National Weather Service who has kind of I don't know if responsibility maybe is too strong of a word, but FEMA relies on the National Weather Service to identify what that incident period is for an event. And a lot of times the incident period is hotly debated, let's say. For instance, if you have subsequent storms over multiple days, well, is that incident period 2 or 3 of those storms, or because the fourth one was maybe a little bit beyond, it's not an exact science. And so something like sea level rise, how that would play into the National Weather Service's calculation of what an incident period is, would be probably very site specific and a good question for them. But I know when we're writing that letter, we would talk to the Weather Service and say, okay, at what time, on what day can people start to look at and say that this damage was caused by this event, if that helps.
Yeah.
I can add a little bit, which is to say that often we sort of conflate what is a disaster with what is a presidentially declared disaster, right? And I know that's kind of the context we're talking about here. But disasters include slow onset events like melting permafrost, right? The impacts of sea level rise over time. There's some question around when ice storms and extreme heat meet the threshold, and the Stafford Act in its current language isn't necessarily really well able to sort of handle that, alongside the questions of whether or not those are the kinds of events that FEMA should step in for or not. So to some extent, this is an open question, but I will say that, in emergency management, it's important to think about all of the different sort of underlying conditions and ongoing day-to-day stressors that are going to impact the ability of a community to be prepared, to respond, to recover, right? And so sea level rise, certainly is having an impact on the kinds of storm surge we see, for example, but that's not necessarily pulled into maps, right? So it does depend on the kinds of mapping that are being done. And other agencies like NOAA have previously made tools available, like a sea level rise calculator. And I'm not 100% certain that all of those tools are still available at the moment. I don't know, Jerry, if you have something to add on the sea level rise and floodplain maps piece.
I'm not sure if those tools are available. I would add in terms of floodplain maps that floodplain maps firms are backward looking in terms of their data. They don't look forward in time, and we probably need to start looking forward in time a little bit more. I call sea level rise the eventual inevitability because it's just so gradual. We don't really perceive it day to day. But that gradual rise is being punctuated by disaster events all the time. And that's, I think, how we see sea level rise, revealing itself.
Great. I think this is a question more for you, Jerry, and I don't know if you can answer it specifically because it's specifically about Texas water law and water code in relation to the NAI framework. And there's civil and criminal litigation policies in the Texas Water Code. They listed there, no person may divert or impound the natural flow of surface waters in the state or permit a diversion or impounding by him to continue in a manner that damages the property of another by the overflow of water diverted or impounded. So maybe more broadly, and I think you touched on this some, but how state code is addressed in the guide, or if you have any comments specifically to this.
No, the NAI guide is strictly federal, nationwide. We haven't looked at getting into specific states. Thomas Rupert, one of my co-authors, is working on a guide for Virginia and hoping that kind of concept, he's going to document how they go about doing it, and hopefully that will be replicated by other law schools across the United States. But we haven't undertaken trying to do state specific yet. It's quite complex. But I think the statute you're referring to from Texas is basically the codification of their tort of trespass. As it applies to flooding and water. And that happens a lot. That's the point. The common law gets modified by legislatures and then it becomes statutory law. But it started out in England a long, long time ago.
Any other comments on that? Thank you, Jerry. That's helpful. Great. So assignments for all those folks on the line to start looking at their state code and developing in the model that Thomas Rupert did. Steve, I wanted to add, there was a question in about the specific case in Ottawa where the folks left the manufactured home park and what happened to those people, and maybe more broadly, if there's some way in plans or how communities are planning, where people go when those properties are acquired through the floodplain bio programs.
Well, you hit the nail on the head there. So I'll start by saying that the FEMA mitigation programs do not allow the use of eminent domain. So, when you participate in a FEMA mitigation grant program for an acquisition demolition, it has to be on a voluntary basis. Where it gets a little bit squirrely is for the manufactured home parks, what it boils down to is it depends on who owns the pad that the manufactured home sits on. And so if it's one owner of all the pads, so you have a manufactured home park owner and all those people rent, then those renters, because they weren't technically, this wasn't voluntary for them, they are eligible for moving expenses. And they're also eligible for there's a thing in the FEMA grants called additions to purchase. So if you can't find a comparable home outside of the floodplain for what you left, then you could qualify for up to, and I don't quote me on the dollar amount here because it's probably changed too, but I think it was somewhere around $22,000 to $30,000 in addition to the purchase amount to help you find that more affordable housing. So FEMA does account for that, in these programs. And, the other thing that I would say is that, reiterate that they are voluntary, but also say that we're not doing folks any favors by leaving them in the floodplain, whether they're rich, poor, or otherwise. The bottom line is that they're in a high risk area. And if we can get them out of there and move them to a safer place, that should be the goal, I think. And the last point you made when you asked the question is, ultimately it's up to communities to decide. A lot of times you'll hear people say, well, if we participate in this acquisition project, we're going to lose our tax base and it's going to affect our sewer, it's going to affect our water. And I turn around and say to them, okay, well then, 9 times out of 10, these communities have access to land outside the flood hazard area. So plan a development where these people can move and move them there, but making some of those choices ahead of time is wise as well. So that, it's just a matter of time before that manufactured home park floods. So, build some stuff now so that when it does happen, you've got some options.
Other thoughts? Okay. Yeah, I agree too. Another question, this is for you, Steve, but maybe others have thoughts. The question was on using conservation easements as a tool for mitigation. How do you ensure the permanence of those easements? Have any challenges arisen? And, so maybe more broadly, what kinds of mitigation projects are available, and are easements one of them?
So unfortunately, FEMA will not allow you to buy vacant land with their grant dollars. So you can't use those kind of covenants or easements with FEMA grant dollars, but you could use them with state or other local funding. And I think that is, again, one of the best options that you can do, is to avoid these problems. Don't wait for something to be built on there, and then have to go back and buy it out later. But let's recognize that the river is going to do what the river does, and that's flood. And it only becomes a problem when we put stuff in the river's way, and especially when we put it in the way and it's built incorrectly. So, that is a great tool. We're not allowed to use it with the FEMA grant dollars. I wish we were, because you could almost draw a ring around cities and say, this is going to be developed in the next 10 or 20 years. Let's buy it now. At least those flood hazard areas and those wetlands and those other sensitive areas, and avoid this mess moving forward.
Agreed. Other thoughts? Okay, there is a question about and you all, I think, all have mentioned sort of the loss of data sources and tools in the last few months. The question is on legal protections for those, but maybe more broadly, where can people turn to find the resources necessary to make the decisions that need to be made in this context?
I'll throw something out there. A lot of organizations, NGOs, academic institutions have taken steps to try to download and preserve some of that data and make it available for folks. So some of that data can still be accessed. With regards to legal protections, I think that's very context specific and in many cases being actively litigated. So I don't feel like I can necessarily speak to that at the moment.
Other thoughts?
I just we'll drop a link in the chat to the ASFPM library, and they are, at least for flooding, a good resource for looking for that type of data. And if it's not currently posted on the website and the ASFPM was able to download it or knows who did download it, they can probably point you in the right direction.
Great, thank you, Steve. And I think I'm going to end because I see we're near the end, but one pretty specific question, I think, for you, Jerry. The question is, if base flood levels are rising, is this higher base covered by surface water law?
Yeah, I would think so. Absolutely.
Great,
It's water.
for sure. Great. Any final thoughts from the panel? Something we didn't get to cover from the questions or thoughts you wanted to end with?
I just appreciate the opportunity to present, and I hope that it was helpful.
I second that.
Also would say thank you, appreciate the opportunity, and just, you know, with regards to some of the questions around buyouts, there's a lot of research in that space. There's some really good resources for folks that wanna think about that and engage in that conversation.
Thank you for that. Well, I really appreciate you all attending. Thank you so much to our presenters. Sarah, do I turn it back to you?
Yeah, thank you, Rebecca. And thank you so much, Alessandra, Steve, and Jerry. This was fabulously helpful, and I'm sure everyone in chat is echoing the sentiment right now. I dropped a few links in chat. There's links to the entire summer school series. This was our very last session, and we're so grateful to everyone for helping us close it out. So you can find the links to all of the recordings, and you can also find the link to the event page where this recording will be posted as well. To gain access to recordings of all ELI programs, including ones that aren't made publicly available, as well as our leading publications, resources, networking opportunities, and more, do consider joining ELI as a member. I've dropped the link to membership in the chat as well. It's free for students, and we recently revamped it, so there's a whole bunch of cool stuff to check out on the website. And again, thank you so much to everybody for joining us today, for all of your thoughtful questions, and for such a fabulous discussion. We hope to see you again at our future programming. So thank you so much, everybody.
Thank you.